I'm ready. Oh, you know, that happened yesterday. Didn't we put batteries in one of the recorders and it went out? Maybe it was Excel. One of them went out and I'm like, I thought we just put batteries in there. Okay, good morning, class. Today we have, okay. Multi-voice. And it's your tests only, okay? Tests only. So make sure you access the speed building and then warm up to that and then listen to your tests, okay? So we have on your 180 multi number 1, proper names, Mr. Itaye, Metropolitan 66, change in pay plan, general manager, document number 34, X, document 34, and Mr. Mahana. Maybe I should move the camera just a little bit so they can see Veronica. Just a little to that side. You'll tell me when, Michelle?
Yes.
Okay. Sorry, y'all. And so,
Good.
and then it falls back like that. Sorry, it keeps.
Yes.
Okay.
Perfect.
Okay. And so general manager, I think, is JM with an asterisk. Am I hitting the asterisk? Maybe GM. Okay, no, it's a brief. I'll look it up right now. Metropolitan is Met-Paul-Tan. You have question by Ms. Dunnett, and starts that way in the middle of the transcript, and then you have Ms. Dunnett speaking in colloquy to the witness. Remember, the witness is always W answer bank.
JMG.
Okay. JMG. Okay, so JMG, thank you, Michelle, for general manager. JMG, like that?
Not the asterisk,
Oh,
just JMG.
Okay, so there's general manager. But if I put the asterisk, no, it doesn't count it. No, I didn't do anything. Okay, thank you. And so that's how you write the words, okay, you all? I am Ms. Dunnett.
The witness,
Miss Mackey.
Ms. Dunnett,
the witness,
Miss Mackey.
okay? And it's gonna start, like I said, with Ms. Dunnett. And this is 180 multi number 1 for 5 minutes, you all. When did Mr. Itaye first enter into a written plan with Metropolitan?
August 1st, 1991.
Is that the document that's been marked as 66, that is change in pay plan general manager?
Document number 34.
Number 34.
Uh-huh.
Do you know why document 34 has a large X on it?
I marked an X through them when it no longer pertained to anything, meaning they were, either the pay plan had changed or they were no longer employed.
Do you recall when you marked this X on this document?
On document number 34?
Right.
On February 1st.
Do you have the original document with you today?
No, I don't.
I'm going to ask whether or not you'll mark that original document and make it available to me.
Does it still exist?
I don't know. I haven't looked at his file since we did that way back when.
We can look for them, but I don't know if they exist anymore. I don't have the originals.
Let's go off the record for a moment. We've made an agreement off the record that in 2 weeks, the defendant will provide plaintiff's attorney with the original documents that have been produced as copies.
To the extent that they still exist.
Okay. And if they don't exist, if we could get a statement why they don't, so that we don't need to do another deposition on what's happened to the documents.
Sure, if there is someone that can say why they don't exist anymore. To the best of our knowledge, we'll do the best we can. We'll look for the originals. We think that there probably still are originals, but I don't want to make a representation that we have originals. And I don't know for sure 100% we still have the originals. But to that extent, we'll produce whatever we have.
The originals of his personnel file? Let me strike that. Did Mr. Itaye's personnel file contain his change in pay plan document?
Yes.
To your knowledge, did you keep the originals for all of the documents?
Yes.
Is there any reason that the original change in pay plan would not be available?
No.
To your knowledge?
No.
Now, you've stated that you marked this document with an X when it no longer pertained. Could you explain that to me more completely? I may not have understood that.
It's so for my own personal information when I go through the payroll files for whatever, that I don't stop to pay attention to this document. I go to the next.
And was there a next document after this that was a change in pay plan?
The after number 34,
Well, wouldn't you have documentation of the change if he simply initiated and initialed it and dated it?
that's true.
So why did you do it that way?
So I'd have 2 documents.
Did he tell you to do it that way?
No,
Did you have to get up from your desk to go to the copy machine?
I would have had to at some point, yes.
Do you recall doing that?
Yes, but at what point, I don't know.
How long was this conversation with Mr. Mahana?
A couple minutes, maybe.
Did Mr. Mahana ask you to make an additional copy of it?
No,
Do you have any reason now that you can recall for wanting to have an original and making another copy of the original?
just a document trail. That's all.
And is it your testimony that Mr. Mahana never made the notation February 1, 1992 on the original change in pay plan document that's been marked as number 34?
Do you understand the question?
No,
I'm asking you if it's your testimony that Mr. Mahana did not make the notation of February 1, 1992 on the original of the pay plan, which has been marked as number 34.
yes.
So he never made any notation on that original?
On the original, no.
And is it your testimony that the large X may have been put on that document that's been marked as number 34 at some time later after February 1, 1992?
That's possible.
Did you also put a large X on the document that's been marked as number 66?
Yes.
And when did you make that X?
After Mr. Atelier was terminated.
I just want to make one clarification. I'm not sure about this. On document number 66, the date 2/1/92 was made by the witness.
By me, uh-huh.
The 1.5% was made by Mr. Mahana, and those are his initials there, but she noted the date. That's not Mr. Mahana.
I did have that incorrect. I thought your testimony had been that that was his notation of the date.
That's her notation of the date, and his notation was done at the same time,
Yeah,
contemporaneously.
And do you believe that in the file right now, you also have what would be the original copy of number? Just in case it's right. Okay. And so we have on your next test, 180 multi number 2, you have Durbin Anderson 98L. And it's all colloquy, so you identify us as we speak. So whatever symbols you use, that's how you identify us. So I am Mr. Harris. Oh, sorry.
Oh, wait, who am I?
Michelle, you.
So I'm Miss Black.
So at least with the court, you all, you can push all the banks and the court will come out, okay? So I am Mr. Harris.
Ms. Black.
The court.
Sorry. I'm Mr. Harris.
Ms. Black.
The court.
Okay, and so this is going to be then 180 multi. Identify us every time we speak. Number 2 for 5 minutes starts with Mr. Harris, myself. And I'm reading, so it starts off with quotes. Plaintiff and its agents were not given express nor implied authorization to complete the note. Page 28 says to the contrary in the deposition, where the defendant stated, oh yes, it was $25,000. I knew at the time it could be filled in up to $25,000. This issue of car title, I object to being raised now.
Well, it's wholly immaterial. I am sustaining the motion, not just because of the statement on page 27, but the statement on page 28, line 9. Question: when you signed the note in blank, you knew that this note could be filled in the bank up to $25,000, correct? Answer: correct. It just seems to me that flies in the face of the contention that he didn't authorize anyone to fill in the blanks.
Your Honor, if I may,
It doesn't make sense. I don't see how the statement at the top of page 28 changes it.
Your Honor, if I may, plaintiff is alluding to, in support of this motion, the statement that I was verbally guaranteeing $25,000. On the face of the pleadings, there is nothing that we have responded to that contradicts that one sentence. Our responses talk about authorization. All he is citing to in his motion for sanctions is a statement that says that I was verbally guaranteeing $25,000. If you look at the face of the pleadings,
Bear with me, counsel. I understand your position. At the same time, I have a hard time understanding why there's not any contradiction when he says that he did not authorize anyone to fill in the guarantee, which amount was $25,000.
that is not a contradiction in terms of the,
As far as I'm concerned, it is. When he said that he guaranteed it for $25,000, to me, that flies in the face of what's presented. I am sustaining the motion.
Your Honor, I have just one more thing to clear the record. There was never a verbal agreement. There was a written note and a written guarantee. The written guarantee was attached to the complaint.
I understand that.
that's not what you have cited.
Just a moment, please. We are not arguing this thing. I have already ruled. I'm alluding to his agreement that he guaranteed verbally. That's the only context for which I used the word verbally. So I will sustain this. As far as the amount is concerned, do you have any contest in that case?
Yes, I do. I have cited in my memo, Your Honor, that the cases indicate that if in fact sanctions are appropriate, sanctions should be imposed only on those hours that are directly related to the pleading that are the subject of this motion. As the court is well aware, the plaintiff filed this motion for summary judgment to obtain judgment on behalf of his client. Most of the hours presented by plaintiff have absolutely nothing to do with what is presented to the court herein.
All right. Do you want to be more specific on his list here?
It is our position, Your Honor, that the plaintiff instituted this action, set up the depositions, and prepared a motion for summary judgment before any questionable pleading that is the subject of this motion was entered. Therefore, the only thing that we think you could possibly impose would be the hour on February 3rd in which the plaintiff prepared the motion for sanctions. Everything else, Your Honor, directly relates to the litigation in order for plaintiff to obtain his judgment.
Counsel, with all due respect, you are putting the cart before the horse. In the Durbin versus Anderson case, it was ruled that you can ask for fees for the time spent in asking for fees. So that latter point as to February 3rd is actually covered by Durbin. So it's not only a question of whether you can ask for fees for the time spent in asking for the fees. That comes at the end of the consideration. The primary consideration is the work allegedly done that led to the sanctions. So we would have to consider everything before that and determine which of these items are proper and which, if any, are not proper. Do you have any statement along those lines?
I would, Your Honor. As counsel has indicated previously, this case was previously heard. There was motion for summary judgment entered. It is my understanding that it was failure on plaintiff's part to prove up that motion for summary judgment, indicating that this case had to be represented, if you will, Your Honor. Therefore, it would seem to me that anything prior to the entry of the motion for summary judgment, which was done previously as well, has nothing to do with the problem with the pleadings that this court is concerned with.
Excuse me, the instant case is a refilled case, isn't it?
It is, Your Honor.
All right, it's a 98L case.
Uh-huh.
Well, everything he is asking for is for services starting in May of '87.
Your Honor, I am trying to make a different point than what the court is considering.
He just indicated matters done in 1987.
Okay. And we'll get ready for your 160s, you all.
Sorry, stopped you.
60. Multi number 1, you have Bronco, Mr. Conaway, Ned Yade, Denver Bronco, and TV. And so it starts at the very beginning with examination by Mr. Boulay. Always Mr. Boulay's witness unless you have Mr. Nielsen speaking to the witness or Mr. Boulay. I am Mr. Boulay.
The witness?
Mr. Nielsen.
Mr. Boulay.
The witness?
Mr. Nielsen.
And this is going to be 160. Number 1 starts with myself. examination by myself for 5 minutes. Now, I don't own season Bronco tickets, so maybe you can enlighten me a little. Please explain exactly what this priority number does for you.
It does not relate to the playoff tickets, except that the option is available to season ticket holders to purchase the playoff tickets if and when they are available.
What is the
Doesn't make any difference what the priority number is. Every season ticket holder has the option to have the tickets for the game, so the priority number doesn't make any difference.
That is right.
Mr. Conaway, you have filed through your attorney an answer and counterclaim. Have you looked over that answer and counterclaim?
Yes, I have.
In paragraph 10 of that counterclaim, you say that the original complaint was filed with the intention to harass you.
I'm confused. Number 10, would you state that question exactly the way you said it before?
Paragraph number 10 of your counterclaim indicates that
Let him read paragraph 10 so that he is not so confused about it.
Let me see it and then ask me.
okay, are you ready to proceed?
Yes, I'm ready to go.
Have you been harassed?
A great deal. We can start out at the first. The most horrible harassment was my wife and daughter who were visiting her parents when Ned Yade walked in with his family and said, "There is the Denver Bronco ticket thieves." That just thoroughly puckered me, and I was hoping he would be here.
How else have you been harassed?
He said, "You guys are going to have to pay thousands of dollars to keep those 2 tickets." And then he harassed my wife in front of her parents and my daughter.
What mental anguish have you suffered? Have you thrown up about this?
No, I haven't thrown up about it. I have lost some sleep.
What mental anguish?
Let him answer. Just let him answer.
Okay, go ahead and answer.
The mental anguish is the continual hassle.
I'll ask Mr. Conaway if you have sought any kind of professional help from the mental anguish you are suffering.
In what regard?
A psychologist.
I think you will find that this has been asked and answered, and that he said no.
Okay, is it a fair statement that simply having the tickets does not necessarily mean that you have to go to the games? Is that a fair statement?
Are you referring to that game or which game?
Any game.
Would you ask that question again?
The ownership of those tickets does not obligate you to go to the game, does it?
No, it does not.
It is like owning a car. For instance, you can either drive it or park it out front. You don't have to drive it.
I am not obligated.
You just get a warm feeling wearing the tickets around?
Well,
Objection to the form of the question. I think that that isn't even a question. I think that is part of a comment on your part.
You agree, though, that you have no obligation whatsoever to use the tickets whatsoever?
He already answered that question.
ask it again, please.
I am asking for, in your mind, sir, there is no obligation by owning the tickets to use them. Is that right?
No, but there is an obligation to myself to get the money for them if I don't plan to use them. If I am not going to go, I am either going to give them to my children to use, or my friends, or trade them for money so that somebody else can go and use them.
Who used the tickets on those games? Was it Ned Yade or?
I am asking you, counsel, please direct your questioning to the pertinent questions before us.
Did you use the tickets on that game?
No, I gave them to my oldest son.
Both of them?
Yes, and I didn't go to the game, so I didn't know who.
How about the other 2 tickets?
I have those in my possession at home.
Counsel, are you talking about the one to get the restraining order, not to dispose of the tickets?
I have them at home. I did not go to the game, and my wife did not go to the game. We left those 2 seats blank, and we did not use those 2 tickets. If I recall, it was a very cold night and day that day, and we decided to simply watch it in front of the TV.
Okay, I think that is probably about it. If you will give me just a second, You are asking for attorney's fees in defense of this action as well as damages. Is that? And we'll get ready for your second. Okay, students, we're back. And so proper names, you have 160 multi number 2, Martha Rojas, first supplemental response. Interrogatory, petitioner's first supplemental response to respondent request for production, certificate of written discovery, Walgreens, petitioner's first supplemental response. Number 3, Ms. Harbor, Ms. Macias, El Paso County, Mr. Gomez. Number 7, Eduardo, Virginia, Peter Piper Pizza, Exhibit 8, Ricardo, Peter Piper, Yolanda, El Paso, number 10, Yolanda Gomez, and number 11. And so it starts with colloquy between Ms. Gonzalez and Ms. Harbor, and then question by myself by Ms. Harbor, okay? I am Ms. Harbor.
The witness,
Ms. Gonzalez.
Ms. Harbor.
the witness,
Ms. Gonzalez.
And this is going to be 160 multi number 2, and it does start with Ms. Gonzalez and colloquy. Okay. It's ready. Oh, is it ready? Oh, yeah.
Oh, sorry. Okay.
Okay.
Oh, I thought you hit it, sorry. Here, the only thing that Martha Rojas works for me. The only thing we acknowledge receiving is the first supplemental response interrogatory, the petitioner's first supplemental response to respondent request for production, file stamped certificate of written discovery and correspondence dated August 21st. And this is a Walgreens receipt. I acknowledge receiving that receipt and I sent a check, but I never received any pictures. I guess she was waiting for me to pay but we never got the pictures. No supplementation was done after we paid.
I'm going to hand you the petitioner's first supplemental response that was delivered on that day. I keep the original obviously in my office. And in response to number 3, we attached black and white copies of the ones she has shown you, and we delivered with that attached, as it says in the response, the photographs from Walgreens along with the receipt and my correspondence requesting reimbursement for those.
I have the original here of the letter by Ms. Harbor asking me for $15.07. And then receipt, and this is what we paid. I have the original here. This is the only thing we got.
Just to give you the entire package, this is what was delivered. The runner receipt, the letter, the receipt from the photos, and the supplementation to the discovery. Obviously, my attachment is not going to have the originals. I've got the original photos now. What was attached to hers were her copies from Walgreens.
But today is too late. You had to supplement. And at no point did we receive. We did get the letter with the receipt. I have it here.
Here's everything.
The receipt for the photos were produced with the letter attached in that, and receipt and the check, but these pictures were not produced. In fact, I have here my copy of the check for $15.07, but no pictures were attached with the receipt, and we never got them. That's my contention at this point. I don't know how many other pictures are there that we don't have, that we haven't seen.
There were 48 that were.
I'm going to object to all the 48 pictures because they were not produced. They were not.
I am going to continue. Ms. Macias, you did have a chance to look at these 9 photos. Do they accurately depict what is shown in these photos?
yes,
Do you recall the dates that all of these photos were taken? What year?
2006. It was for my son's birthday again.
And those were taken here in El Paso County?
Some of them were taken, absolutely, they were in El Paso. Some of them in my son's school, and some of them are in the backyard of Mr. Gomez.
So this is number 7. Can you tell us what that depicts?
This is Mr. Gomez holding my son, Eduardo.
Who else is pictured in that photo?
Great-great-mother, Virginia.
And where was that photo taken?
Peter Piper Pizza. That's where my son likes to go.
Now, I'm looking at what I've marked as Exhibit 8. What does that photo depict?
That is my son, Ricardo,
And
and Peter Piper. How would you call it?
some type of mascot?
Yeah, I think it's the Peter Piper mascot.
Okay, look at what I've marked as number 9. Who is depicted in that photo?
In this picture, it was in the morning. I was here and I walked my son to school with Yolanda, and we were having breakfast. It was him, his brother Eduardo, and myself there.
And that was here in El Paso as well?
Yes, at Ricardo's school.
And I'm now showing you what's been marked number 10. What does that photo depict?
It is my son Ricardo, Yolanda Gomez, and Virginia again, which is Yolanda, the great mother and the great grandmother.
Where was this photo taken?
It was at his birthday party at Peter Piper Pizza.
Let me show you what's been marked as, I'm going to mark this as number 11. What does that represent?
This is my son Ricardo and I in the backyard of Mr. Gomez and his dog.
At their home?
Yes, here in El Paso.
When was that taken? Do you recall?
It was, of course, it had to be in my travel, so it was in 2006.
Now, take a look at what's been marked as 12.
And this is Mr. Gomez and my son Ricardo and the dog that was in the other picture
Here in El Paso?
in the backyard of his house in El Paso.
And then finally, we'll show number 13. Do you recall where that photo was? Okay, well, so that concludes your tests. Make sure that you access the speed building prior, and make sure that you're engaging in the discussion forum because it'll be in effect next semester. And just so you know how to operate it and navigate through it, okay? Have a great day, you all. Have a great weekend. We'll reconvene next Monday.